Hey, good morning, good afternoon, good evening, depending on what part of the world you are in. This is the Big Girl Diary. Cookies, cookies, cookies. Okay, I got some good stuff for you. Um, the Evan Rachel Wood, her special motion came out, and I managed to get my hands on it. It was expensive, but I got it. Now, I find it interesting. There's a lot of back and forth. Marilyn Manson won some things, and Evan Rachel Wood and Ilma Gore won some things. So I'm going to break this up into different parts because this thing's about how many pages is it? Oof, it's a big one, 34 pages. So what I'm going to do is I am going to do this couple of pages at a time, or if not, we'll be here for 2 hours. And I know that my beautiful face is really beautiful, and I know you like looking at it, but I don't think you like looking at it for 2 hours. I'm so silly. I'm so silly. Oh my goodness. Alrighty, now I have the whole court case, not the whole court case, but the motion on Discord. I was not able to bring it up here for some reason. They don't want me showing it. They don't want anybody showing the court cases. No, they just make it difficult. But one day we're going to find a way to put it up here. I believe that. All right. Okay. Now, what I found interesting was I looked in a couple of places and what they used to cite their sources on why they made the statements that they made, having to back it up. Now, we'll go back a little bit. When you're in high school or even in getting your associates or bachelor's or master's or even PhD. It all goes through the same thing. You have to be able to support what you're saying. You have to be able to show evidence of it. So they cited some case law, which I found was quite interesting. I'm like, okay, Marilyn Manson's lawyers, why did you? What was your thinking? Why this one? Could have found something a little bit better, but after reading through the whole freaking thing, you could also find it on Discord as well. You'll get an understanding of why they did what they did and why the judge ruled the way she ruled. So, all right. So let me go to the the motion. Okay. Now it goes through the background again. I'm just going to mention it just real briefly to keep it in mind, and how Evan Rachel Wood and Ilma Gore are trying to fight these complaints or calls of action, and they're trying to combat it. Now, the calls of actions are intentional infliction of emotional distress, defamation per se. Three, the violation of comprehensive computer data and access fraud act, and the impersonation over the internet. And that's a penal code. Now, I didn't look that one up, but as we go on, I'll introduce that. So, okay, that's the background. Now what I find interesting here is this: the request for judiciary notice. Now, judiciary notice is this. Notice is just simply this: in the law of evidence, the power of the court to deem the burden of proof to be established as a particular fact without the introduction of evidence, because the facts is one that is a matter of common knowledge or is readily demonstrated by the reference of source of unquestionable authority. So that right there is what judicial notice is. When I found out, I said, oh, that's what that means. Okay. And look, I'm learning as I'm flying this plane. As I learn, you learn, and we will be knowledgeable together. Okay. Um, so here, this is what Wood does. The court grants Wood's request for judicial notice as the exhibit 6, 7, 8, 9, and 10. Now I'm trying to find these exhibits because I'm like, and I'm looking through old stuff back from last year, all these motions, and I got so much stuff stored. But I'm going to find it. As to item 1, Wood's request, the court notes that a party requesting judiciary notice of material under Evidence Code 452 or 453 must provide the court and each party with a copy of the material. And that's what I put on Twitter, that Marilyn Manson was requesting the, oh my goodness, Evan Rachel Wood's phone back in, what was it, June 22nd, 2022. And I mistakenly, and thank you for you all for keeping my feet to the fire, letting me know that, no, that wasn't the judge. That was Marilyn Manson doing that. So I'm like, oh, reading is fundamental. Okay, the material in part of the file in this court in which the matter of being heard. The party must, 1, specify in writing the part of the court file sought to be judicially noticed, and 2, either make arrangements with the clerk, and the clerk is a very powerful person in the court system, the judiciary system. It is the clerk, to have the file in the courtroom at the time of the hearing, or confirm with the clerk that the file is electronically accessible to the court. And it's California rule. Wood has not provided a copy of the material, and she requests that the court judiciary notice the item. Now, I don't know if you remember me saying, or even saw on Twitter, I'm like, look, Marilyn Manson has been requesting this, and you haven't provided it. So now she's like, hey, I got this. I want to bring this in like now, but I don't want to come in as evidence, but you know it's out there, but I want it to come in like this. Sneaky, sneaky, sneaky. So, and also the core and Imlla, and this is where it gets rather interesting here. The court grants Imlla's request for judiciary notice as to Exhibit 2. The court denies Imlla's request for judiciary notice for exhibits, and it's 1, 3, 4, 1, 3, 4, 5, 6, and 8. And it's interesting because as the news articles, Gore cites Ragland versus the U.S. Bank National. Okay, I'm not going to get into that, but it is a case that the Court of Appeal. Okay, may we take judiciary or judicial notice of the truth of the content on the websites, blogs, including those in LA Times and Orange County Register. The content of the websites and the blogs are plainly subject. Okay. To interpretation, and for the reason not subject to judiciary notice. Very interesting. As a part of websites, the court of the truth of the content in the article in the web are not proper matter for judiciary notice. And the facts that the article in the website were publicized is irrelevant to the issue before us. So my question is this. Very simple question. Simple one. What was she trying to get in? I mean, they're saying, okay, we see this, and no. But it has no relevance to this case here. So I'm trying to I'm trying to find it, and to no avail. But it's out there, and I'm going to find it. I don't know when, but hopefully I can find it. I don't know if you remember that I said that I thought that Imlla Gore was going to get out of a lot of this because everything that Evan Rachel Wood said, she said it to Imlla Gore, but Imlla Gore never bothered to, I guess, look into it. But they were in a relationship. Evan Rachel Wood told her these things, and Imlla, being reactionary, just went out there and did it. Now, I think, let me hold off on what I think. Okay, here's the part within the where Imlla won. Yeah, I know. Brace yourself. As an element of the formation and operation of the conspiracy, this right here goes along with what Marilyn Manson was saying about recruiting people, and there was a conspiracy to go against him. The plaintiff asserts that Gore used the falsehood about groupies to recruit prospective accusers on behalf of Wood and her Phoenix Rising entity. The plaintiff cites the portion of Gore in October 25th, 2022's deposition, transcripts in support of this assertion. Now, I didn't get Gore's declaration. Deposition, I'm sorry. I wouldn't have access to that to begin with. Okay, King's declaration, Gore's deposition, deciding where it's at. The plaintiff also cites to Gore's testimony, I've told people that I believe the participants in the video were underage. And when asked, you told to, Gore responded. She said that Catherine McGracken and I believe Evan Rachel Wood and Esme Bianca. The plaintiff asserts that Wood saw the film and did not tell Gore the actress was of age, plaintiff cites in the testimony. Did Miss Wood ever tell you she had seen the video? And he answers yes. Question: did she tell you that the actress in the video was underage? I don't recall the specifics of the conversation about groupies with Miss Wood. So, on one hand, and look, like I said in another video, I had to rethink it because Imlla is a lot more savvier than one thinks. So she's quite careful on how she's answering it. She's saying, well, I believe they were underage. I believe. That is in the state of mind going according to the things that Evan Rachel Wood was saying. So, and then she says, well, I don't recall the specifics of the conversation about groupies, but you can run around calling him a Pedialyte filer around playgrounds. So then it goes on to say, Wood counters that failing to correct a statement does not demonstrate a conspiracy to defame, particularly absent evidence that Wood knew the statement was false or was being made to anyone else. And I gotta say that right there, it's kind of hard to prove because she didn't know. Ilma was running around saying, "Hey, you Pedialyte filer around the playground." Okay, where the Court of Appeals note that the basis of the civil conspiracy is the information of the group of two or more persons who have agreed to a common plan or design to commit a torturous act. What they were using, what one of the court cases that they used to back up what they were stating and to give additional information for the judge to be able to rule. Said, okay, this happened, this is happening here, but it also happened there, and this is what the judge said in that case. So this gives us power to further prove, because there is a case precedent on it. And I hope I brought up the right one. Okay. Okay, we hold the exempt where the statutory exemption applies and an employer of a former employee cannot use other employees' basis on the conduct relating to personal action. And even though this right here is a case to where an airline to where someone got fired, and the person who got fired believed that the other coworkers went to the supervisor and said things about the employee, which made the supervisor look at the person sideways and then gave them a bad evaluation, which led to them losing their jobs. And they thought that it was a conspiracy and also emotional distress along with it. So I just want you to have that background. And note that the right to sue for liable in governmental statute or governed by statutes, and that the legislation has prescribed the circumstances under which the cause of action and the defense and the privileges pertaining to thereto may lie. In thus we reverse the judgment. So in the lower court, they were like, no, but as they went to the appellate court, they're like, no, we reversed it because of this. So that's why they used it. But that's not the part that I was trying to get to. Oh, man. Shepard filed a grievance under the collective act in bargaining and the agreement over the termination. And he claimed that the evaluation of his performance had been falsified in an elaborate conspiracy among his co-workers, which caused him to fail to be upgraded to a captain, and ultimately his termination. Especially Shepard contended that another pilot, flight attendant whom Shepard had a bitter argument with, and after the argument, the Hardyman and harbored ill will towards Shepard. And okay, so you basically have that understanding. And I have seen that happen. Oh man, oh man, oh man. There are some people that I don't know about this guy there, whether he was a likable person or not, but there are people who would promote a person because they might be a terrible employee, but they can't fire them on anything what they're doing because it's not going against policy, but they can promote them up to a higher level, knowingly that they will not be able to perform the job. And they're like, oh, well, I got status, and they'll bite at it. Take the job, get a promotion, and then be let go. All right. Okay, let me go back to the. Now, the court does not find that the plaintiff has demonstrated that Wood had concurred in Gore's allegation or alleged defamatory statements about Groupie uh, with with knowledge of the unlawful purpose or Wood intended to aid in achieving Gore's objective in making such alleged defamatory statements. Based on the foregoing, the court does not find that the plaintiff has demonstrated probability of prevailing in his claim based on alleged defamations against Wood. Yes, I'm like, oh God. The plaintiff notes that Wood moved to strike multiple allegations of the plaintiff, and then he used a notice of okay. The plaintiff asserts that the court should not strike allegations that provided context to other claims. The plaintiff notes alleged of protected activity that merely provides context without supporting a claim of discovery cannot be stricken under the anti-SLAPP statute. The plaintiff assessed that allegations describing acts under the done to further Gore and Wood's campaign against Marilyn Manson supplied the background and the context for the cases or the causes of. The plaintiff asserts that the allegations describing the act done to further Gore and Wood's campaign against the plaintiff or Marilyn Manson supply background and context for the cause of action arising from the hacking, swatting, and impersonation of the plaintiff Marilyn Manson, which are not challenged in the motion. Okay. Wood counters that the plaintiff cannot backdoor his stricken claims back into the case of recasting the FBI letter, recruitment, and the groupie allegations as context for his swatting and hacking and impersonation claims that would subvert the purpose of the anti-SLAPP statute. Wood notes that refusing to strike any part of a cause of action, the rest of the part of the protected activity defeats the legislative goal of protecting defendants from meritless claims based on the conduct. Oh, this is hard. This is hard. I want to. Okay, I'm done. Just like you, I know you want to just. All right. So let me give some context. Even though the FBI letter, without using Brighton Gore's test or Brighton Gore's what is it called, declaration, they had to look at the information at face value, and that's all that they were able to do, which I get. So they pushed that part out of the FBI letter, but they kept her mental state in. So he lost and won. So here is he's trying to slowly bring the information in, but Woods are like, nah, you're not doing that, Marilyn. I know what you're trying to do. No, this is something. So let me see. Okay, what counters that no matter who is the target of the plaintiff or Marilyn Manson, he'd claim based on the FBI letter, the FBI letter claim is barred from litigation, privileged because the plaintiff only learned of the letter from Wood's filing. Oh, wait a minute. No, 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 no. He learned of the letter. No, I don't think that's true. I got to track this down, this statement down. Okay. In addition, as Wood notes, the plaintiff cites, was that NC authority of the proposition um, that the court can decline to strike a claim from the complaint after finding that it arises from protected activity under uh, protected activity and lacks merit. Wood also cites Burrell, where the court found that the scope of the term cause of action in section 425.16b1 parentheses is evidence from the statutory context when the legislator declared that the case of action arises from the activity furthering the right of the petition or free speech with may be stricken unless the plaintiff establishes the probability of prevailing. It had in mind allegations of protected activity that are asserted as grounds for relief. The targeted claim must amount to the cause of action. In this sense, that is, the alleged TC justify a remedy by referring to the cause of action against a person arising from any act of a person in furtherance of the protective acts of petition. Said speech, the legislature indicated that particular alleged acts given rise to the claim for relief may be the object of the anti-SLAPP motion. This is a case involving the allegation of both protected and unprotected activity, and the plaintiff is required to establish a probability of prevailing in any claim for relief based on the allegation of protected activity, unless the plaintiff can, or Marilyn Manson can do so. The claim is its corresponding allegation must be stricken. Oh, all this long-winded stuff is outrageous, and I'm sorry that make your eyes cross. Oh my goodness. Neither the form of the complaint or the primary right to strike is determined or determinative. This is going to get wild. So far in these two cases, Marilyn Manson won, but he lost a couple of motions. So he tried to get that letter back, or the FBI letter back in. And I'm just hoping one of them opens up their mouths and introduces it by mentioning it like Amber Heard did, mentioned Kate Moss. And no one spoke anything about Kate Moss, but once Amber Heard said Kate Moss she mentioned it. So let's keep our fingers crossed that she mentioned the FBI letter. Let one of them just slip up somewhere, anywhere under the rainbow. Okay, so this is one portion. I'm going to maybe do two more to give you a deeper understanding. This is a whole lot. So, Cookies, thank you. I thank you. I thank you. I thank you. But on that note, Cookies, thank you for taking time out of your busy schedule. Bye bye.